Thank you all so much for coming to the first of what is our several-part series on an executive debrief of Roe versus Wade. Today, we're going to be talking about the implications that the United States Supreme Court decision of Dobbs had on the entire reproductive health landscape, and really what that means for your healthcare, reproductive health, femtech, or other business. And so that's, I think, a lot of questions that we're starting to get and see as we see how this landscape unfolds. So very excited to be talking about that with you today. Hopefully we'll be able to provide information that can be useful for you. This series does last for several days. So it's every day for the next week, about week and a half at noon Eastern. So if you're unable to make this recording, please join us again later in the week. And I want to start first with a quick disclosure. All right, I am an attorney. I'm not your attorney unless you've signed a retainer agreement with Nixon Gwilt law. And so today's video is really only for informational purposes only. It should not be considered legal advice. And before making any decisions for your healthcare business, it's always advisable to have a candid conversation with an attorney about your specific circumstances. So I just want to say that out there. And so the advice that I'm providing today is also my own opinion. It does not reflect the opinion of any of Nixon Gwilt's clients or the firm itself. So I'm going to start this series by focusing on one issue for each day. And there's many issues that we could talk about. The first and foremost of which seems to be on everyone's minds is privacy and security. So there has been a lot of talk, I'm sure a lot of you have seen this in recent publications, right, newspapers, news outlets, about women's health data being potentially accessed by law enforcement officers or by the courts. And so I want to unpack that a bit, and I'm going to explore that from both the perspective of a femtech app or a different type of healthcare app, right, that's not subject to the Health Insurance Portability and Accountability Act or HIPAA. And I'm also going to address that from the provider side or the covered entity side, which does have obligations under HIPAA to safeguard patient information and really unpack kind of what the legal obligations and ramifications are there for disclosure. So I will start first by addressing this scenario from the healthcare technology perspective. And so I'll address it from the femtech perspective, but please know that anything that I'm saying really applies to broader healthcare business models as well. So in the femtech context, a lot of the apps or the platforms that are created to provide advice or services or products to women are being created outside of the context of HIPAA. A lot of consumers don't realize that. There's a lot of misconception that happens from the consumer side whenever they're trying to access these products or these applications. And there's this perception that HIPAA applies to all types of healthcare data. That's unfortunately not true. Anyone who's in the healthcare business really knows that HIPAA only applies to a very limited subset of data provided by a specific category of entities. And we'll get to that momentarily. So HIPAA is not really applicable to a lot of the femtech or healthcare tech apps that are on the market today. This means what's the regulatory landscape for what's governing them, right? What governs them mainly are state laws. There are a handful of states like California that have very robust privacy protections. There's a lot of states right now that are trying to pass those privacy laws. And then there's the Federal Trade Commission, which is regulating making sure that things like the privacy policies, right, the actions of those companies are not unfair or deceptive towards consumers. So that's the regulatory structure from the privacy perspective that's principally governing those femtech apps or the health tech apps that are on the market today. The concern that a lot of consumers are having right now, especially since the Dobbs decision, is that they don't feel that their health data is being adequately protected within those applications and those products. And there's a fear that law enforcement officers could get access to that data. And the fear, right, is that once law enforcement has access to that data, they'll use that data against a woman in a state where abortion is prohibited in order to try to convict her of a crime. So the question that I get a lot, right, is, A, is that a legitimate concern? B, what can we be doing to enhance, right, or really increase the privacy protections that we are giving to our consumers? And C, are there any business risks for my femtech company if I don't increase my privacy protections, right? So those are kind of the three categories that we get a lot of questions about. So first, this is a legitimate concern. A lot of times people think that this is just a theoretical or purely speculative issue. It's not. There are tons of instances in which technology companies have been served with subpoenas or requests from law enforcement officers or courts to try to get access to data that's being held either in the cloud or on a cell phone or a different type of application. Additionally, back in about 2017, there was a case, I believe it was in Missouri, where law enforcement officers were actually able to get a hold of a woman's search history on Google, and she was searching for abortions, and they were able to use that to show that she had an intent to procure an abortion, and then they were able to try her in a court of law for that activity. So not purely speculative, and there are numerous ways in which law enforcement can actually get access to that data. So one way in which they can get access to the data is by a subpoena or just a request to the company. And oftentimes companies, especially in their privacy policies, will have an exception that allows for the disclosure of data to law enforcement officers. Consumers have not really paid much attention historically to privacy policies. They are paying much more attention right now to femtech privacy policies, and we're seeing that bleed over into other healthcare contexts like mental health apps or just more generalized telehealth apps as well, because consumers they're becoming more and more concerned about the privacy of their data, and they're realizing that's not only reproductive data, there's other sensitive health data that's out there. So that basically means, right, femtech is kind of where things are starting here with respect to consumer concern. It's not where things are going to end, and we're going to start seeing shifts in how data is protected and how data has to be protected along all verticals in the healthcare industry. So that's at least something that a lot of people aren't considering right now. They're thinking that it's just femtech, right? This is just reproductive health data, and that really negates the downstream impacts this is going to have. So that's one way law enforcement can get access to data. The other way that they can get access to data, and this is the more concerning way, right, is through downstream data selling or data disclosures. So once data leaves that femtech company, right, the femtech company doesn't have any type of control over how that data is used or disclosed downstream once it's sold or given to a third party. And consumers don't have control over that either. The policies, typically the privacy policies, will disclaim any type of downstream use of that data once it's out of the hands of the company. Now, what a lot of companies will do, right, is sell that data downstream to data brokers. Data brokers then compile that data and they can sell it publicly. I could go buy from a data broker, you could go buy from a data broker, law enforcement can go buy data from a data broker. And that was what Vice had recently shown, which was it was able to actually go buy, I think it was for about $160, data that showed which abortion clinic or pregnancy clinic a woman went to, when she went, what time she left, where she went after. And all of that data can be used to compile an idea of who that person actually is. And so you can kind of start to re-identify who these people are based on the types of data that a data broker has and is selling. One primary concern here is that law enforcement officers can get data from data brokers that they would otherwise need a subpoena or a court order to get from the company itself. So this is also kind of a back way workaround for law enforcement to get access to data. And then the third way in which law enforcement can get access to data has to do with security. So nobody is really talking about this right now, but reproductive health data, the value of it has skyrocketed. So health data in and of itself has been valued on the black market at about $250 per health record. And that's a lot whenever you consider how much things like financial data and credit cards are going for in the black market. One credit card maybe goes for like $5.60. Health record, $250. And the reason for that, right, is that the amount of data that's in a health record, that can really give someone a lot of personally identifiable information. You've got potentially social security number, financial data, all of their health history, all of their medical record numbers. And that can lead to a lot of downstream consequences, especially with respect to identity theft. And here's the thing, right? You can change your credit card number. You cannot change your health history. So once it's out there and it's exposed and somebody has that, there's a lot of consequences. What can happen though, is now we've got an environment in which reproductive health data can serve to prove a crime, right? Especially in states where abortion has been banned or criminalized. Reproductive health data is going to be something that is sought after by hackers much more than in the past. And so what's going to happen here is I anticipate we're going to see a lot more increased cyber activity against not only femtech apps or those types of health tech apps, but also against provider organizations, hospitals, even primary care organizations, right? You might think this only applies to OBGYNs, right? Or those types of healthcare organizations out there that are doing abortion or actively providing reproductive health services. That's not the case, because given this landscape, women may feel uncomfortable now going to get reproductive health services from somebody who is classified as a reproductive health care provider. And so maybe they'll go have this conversation with their primary care physician, thinking it's less likely that a law enforcement officer is going to subpoena her records from a healthcare provider than from a reproductive healthcare provider. So cyber criminals are aware of this changing landscape. They're also aware that that data can be used to prove a crime, and so it's high value data. So if a hacker is able to get a hold of that data, what they could do is not only hold that data for ransom from the actual company which it got it from, and that's hugely problematic. It can run a lot of companies out of business, because they're going to hold it most likely for a higher ransom, because they know if this information gets out that your company had a breach of this type of reproductive health data, that means, oh dear, right? There goes your entire reputation and your entire way to make money. So they're going to be holding that for ransom. To the extent that they're then able to re-identify any of that individual data, what they can do is try to go after that person individually and say, hey, I've got your data here. I'm going to extort you for X amount of money. If you don't pay me, I'm going to turn this data over to law enforcement officers, and they're going to come and try you for a crime. So that is a new aspect to this landscape that a lot of people are not considering, have not considered, and are probably not prepared for. The reason for that, right, is that it's twofold. If you're a startup company, right, you have limited funds, and totally understandable, right? You want to be putting your money into product development, product design, commercialization, go-to-market strategy. Privacy and security are typically things that fall off the radar. So a lot of the femtech companies and the startups that are out there don't have that type of robust privacy and security protection that a lot of other companies have who have been in the market for several years. So cyber criminals also know that, right? And a lot of times what I hear from startup companies who come to me and want to know why they even need to be thinking about privacy is, I'm a really small company. They're not going to come after me. They're going to go after a larger fish in the sea who has more data. That approach is wrong for a couple reasons. First, if you have reproductive health data, they're going to come for you, no matter how small you are. And cyber criminals know that you probably have a lot less security protections, so you're going to be a much easier target. You're kind of a low-hanging fruit for them. Second, to the extent that your company has industry partnerships, say with hospital organizations, with pharmaceutical companies, anything like that, they might not be after you, right? Maybe the health data you have is pretty small. What they would be after in that case would be the health data of your partner company. And so they use your company as a stepping stone to hack into and breach the data from the other larger organization. So when I try to counsel startup companies, especially about why privacy and security are important, those are the types of things I try to express. There's also a nice business aspect to it, right? So not only does having strong privacy and security really safeguard your customers' data and your partners' data, it also can serve as a business advantage, because whenever you're making those partnership deals, those companies, especially if they're covered entities or entities that are very well known within the healthcare industry, they have very strict standards for who they're going to contract with. So if you don't have a privacy and security system that is strong enough to meet their needs, you're going to have to spend time building it. That's going to take you 6 to 9 months. That's going to delay your deal or your funding for 6 to 9 more months. So it's also a business advantage really to start thinking about privacy and security now. We've got this changing landscape. It's going to help you longer term. And it's also something that consumers are looking for now. Consumers before did not place a lot of emphasis or even attention, right, to the types of privacy and security policies that companies had. I can tell you, I don't know anybody who actually sits there, right, and reads the entire privacy policy of an app or a product that they're using. Nobody's got the time. So now, though, they are, right? There's that risk. People are paying attention. People are looking. To the extent that you, especially as a result of this decision, right, decide to implement stronger privacy or security protections, you should let consumers know that. Let them know that you hear that they're scared. You hear what they're afraid of, and you're working to reinstill their trust into the healthcare community as a result of everything that's happening. And here are the changes that you've made, right? Maybe you update your privacy policies so that you're no longer disclosing data downstream. Maybe you've created a data map and you're able to determine which types of categories of data you no longer need to be collecting. A lot of companies collect much more data than they need. And as a result, you've got a lot more data that can be hacked or accessed from law enforcement. So think about whether or not you really need all of that identifiable information you're collecting. Can your user get the same type of output from your algorithmic prediction or your product without giving their email address as if they gave their email address, or without telling you their height or their weight? Can they still get the same predictions? It's going to depend on what your app is doing, right? On what your product does. Maybe you can't, right? Absolutely fine. The data you're collecting, you've determined it's necessary. You've at least done that research through a data map to know exactly what types of data you're collecting, where it's going, where it's being stored. And that places you in a much better position should something unfortunately happen with respect to a cyber attack. You're able to much more easily see what data could have been compromised, where it was stored, and shut it off before that system gets infected and before another system gets infected. So those are the main types of considerations, questions, concerns that I'm seeing from the startup side for companies who are kind of in that femtech reproductive health space. Shifting over to the more covered entity provider side, there's a lot of confusion still around HIPAA. So the way that HIPAA works, right? HIPAA is a very restrictive law that governs the disclosure of healthcare data if that data is protected health information. And that's a defined term under HIPAA, right? It's personally identifiable information that then is related or can be linked to past, present, future health, medical conditions, that type of stuff. That's the classification of data that's protected. And HIPAA is only applying to covered entities and their business associates. So if you're a healthcare provider that's billing insurance, your healthcare clearinghouse, those are the types of covered entities, right? Health plan that are going to be covered by HIPAA. So you've got to have PHI and you've got to be a covered entity or contracted with a covered entity as a business associate for HIPAA to even apply. So we often see HIPAA most often in the context, right? You're a hospital system, you're a healthcare provider, you're a health plan. Those are the common contexts in which these types of questions can arise. The question that I am seeing most often right now is, when are healthcare providers or healthcare organizations that are covered by HIPAA required to disclose reproductive health data to law enforcement? So the HIPAA privacy rule really operates by saying, no, you can't disclose data, right? That's kind of the baseline foundation of the HIPAA privacy rule, is a prohibition against disclosure unless it's mandated or unless it's permissible. And there's only two very limited circumstances in which health data is required to be given. Law enforcement officers, right? Subpoenas, court orders, they're not falling in that required category. That required category is extremely limited. Where law enforcement officers, court orders, those types of requests fall is in the permissible disclosure category. So the permissible disclosure category is really saying you're not required to disclose it, but you can disclose it for XYZ reasons. And there's a long list of reasons. The one that a lot of people are most familiar with is the treatment, payment, healthcare operations exception. And that would allow you to, exchange data with another healthcare provider, another healthcare entity to coordinate the patient's care, help you use that data for your internal administrative functions. Law enforcement officer requests, disclosures that are required by law, as well as court orders, fall within that permissible disclosure framework. What that means, right, is if a law enforcement officer comes to your organization, HIPAA-covered organization, with a subpoena and says, I want to get Cindy's reproductive health data. I've got a subpoena for it. Give me that data. You've got two choices. You can give the data. You can absolutely do it. It is a permissible disclosure. If it's by a subpoena or other lawful court order, you can give that data over. It would not be a breach. It would not be any type of impermissible disclosure. It is acceptable. You could also choose not to disclose that data, right? Permissible, not mandated. A lot of times what's happening is organizations should have, and if they don't, they should develop policies and procedures around when data should be turned over to law enforcement officers if you receive a subpoena request or a court order request for that data. And what that means, right, is that you're gonna want to have a policy, especially if you are at all in this healthcare industry right now that at all touches reproductive health data. And this is true not just for these healthcare provider organizations, right? If you're a company that provides emergency contraception, you're an app, right, that allows people to get access to different types of birth control, you're going to want to have a policy and a procedure in place that says how you're going to handle these requests when they come in, because they're going to come in. You're absolutely going to start getting these types of requests. And the last thing you want to do is have this request come in and sit there and think, I don't really know what I should do with that. I don't really know what my rights are or what I'm obligated to do with that. I'm going to freak out and I need to figure this out right now. Think about it now. Think about what you want your company's position to be. Do you want to be giving over that data? You want to be compliant with law enforcement officers? You think that that's the right thing to do? Build your policy around that. You instead want to have a very patient-centric, privacy-focused organization. You don't want to give the data unless, it's absolutely required by law. Build your policy around that, right? Pick a policy for your organization, pick what fits best with your values, and develop those policies and procedures now, because it's going to happen. It is, and people are going to be confused when those requests come in. If you are at a larger healthcare organization, you should not only develop this policy and procedure, but do training on it. If you've already got an existing policy and procedure on this, train employees up again. It's probably been a long time since they've seen this or even thought about it. So training can be really essential to make sure that everyone is following the same types of procedures and understands what they're supposed to do and how they're supposed to escalate an issue. So that would be one recommendation. Another recommendation, right, is to make sure that you're communicating with patients. It's just right to make sure that you're communicating with your patients. Make sure that they're understanding as well what's going on in this landscape. Everyone is really concerned, right? Everybody is really freaking out. They're not sure what this means. There's a lot of misinformation out there. So to the extent that you can, right, talk to your patients, talk to anybody, right, who's interacting with your organization about your policy on this, about your stance, what your organization is doing, and how you will or will not disclose their data. They'll appreciate that, even if your response is, yeah, if we get a subpoena, we're going to disclose your data. That's our organizational policy. You've been upfront with consumers. They know your stance on it. And if they choose to go elsewhere because they're very uncomfortable with that in a state that's very restrictive of abortion, that's their choice, right? And they can have an informed choice. And that's one of the things that a lot of privacy policies and organizations aren't giving to consumers right now, is really that type of a choice. And I did forget to mention at the outset that if you do have questions, there is a Q&A function. There's also a chat. So if there's any questions that you would like me to answer during this time, I'm happy to do so. If you put a question in either now, right, or during another session, and I don't have time to get to it, I will follow up with you via email or LinkedIn, or however is the best way to communicate with you, to make sure that I get you those answers as well. So I want to make sure that you all have the chance to ask the questions that are on your minds, that you're seeing most in your organization, to help make this the best and most informative session that it can be. And additionally, if there's questions that you want to send ahead of time for me to consider as we're talking through these issues over the next few days, happy to accept questions through LinkedIn or via email as well. And so, so there's a question here, right? What about policies and procedures for when LE asks companies for requests, law enforcement asks companies for requests for information for employees who take advantage of companies' internal policies providing money for women seeking abortions? So I believe, and correct me if I'm wrong, right, this question is kind of asking what's going to happen when a law enforcement is coming and asking for requests for information for employees who take advantage of companies' internal policies. Okay, yeah, so there's been a lot of talk right now about companies providing abortion benefits for their employees. A lot of companies are starting to think about whether or not abortion benefits is something that they want to offer. They see it as a way to not only, stand up against the injustice that's happening, but also to be really supportive of their female employees. They see this as, a kind of a healthcare access issue. And so that's something that companies are really thinking through. There's a couple of risks if you are a company that decides that you want to provide abortion benefits for your employees. The risks here are several, right? First is you've got to think through how this is going to work operationally. There are a lot of privacy challenges when it comes to actually implementing this design. For instance, right, are you going to offer the benefits under your employer-sponsored health plan, or are you going to offer these benefits separate through the company itself? If you're offering it through the company itself, the problem that you've got there potentially, right, is that there's not that boundary between health data flowing to the company versus staying within kind of the insurance context. So employees are going to feel less comfortable using abortion benefits that are being provided directly from the companies because their employer could get access to their healthcare data. That data could then be used to take a negative employment action, right? They could be demoted, they could be terminated. And even though that's not a lawful basis to terminate somebody or demote them, it could be one bias, one factor in the overarching decision. And there's no way to prove, that it was or that it wasn't. So that's kind of the main privacy concern there. What this question is getting at, right, is that companies that have those types of policies and procedures for employees who are going to take advantage of those internal policies, what happens if law enforcement comes to that company and says, I hear that you are providing abortion benefits in this state. I want to see your company's policies and procedures on that because I think what you are doing is either illegal in the state, or where we're seeing this being a very big concern is in states where there's aiding and abetting laws. And that's especially prevalent right now in Texas. So absolutely true, right? If you've got a policy or procedure, that's not protected PHI, right? That's a company policy or procedure that would be subject to the subpoena, right? The court order, you would have to turn that information over pursuant to lawful employment requests, lawful law enforcement requests. You would not be able to withhold that data under HIPAA at all. And the problem there, right, is that in these aiding and abetting states, what can happen, right, is that law enforcement gets wind that your company is offering these abortion travel benefits. They are able to say, by offering that benefit, you're now encouraging a woman to get an abortion in a state where abortion is illegal. You're encouraging her to cross state lines to get that procedure. You company are now aiding and abetting. And so therefore in states, and it will depend on each state's laws. For the states that decide to have aiding and abetting laws, in Texas, I believe it's private citizens who can sue and not necessarily the state. So that's kind of what's going on there. So then you as a company, you risk having to go through a lawsuit, whether it is a legitimate lawsuit or not, right? Who knows how the court would determine that. Regardless, you've still got the expense of hiring an attorney. You've still got the issue, right, of you've got to go through discovery. Your policies are going to be discoverable. The thing that worries me that also nobody else is talking about, not all employees at the company are in favor of abortion. Right, so their companies are kind of making these blanket policies, and they're assuming that this is some benefit that everybody wants. You may have individuals who are against abortion who are living in a state where there's an aiding and abetting law, and they may be a whistleblower. You don't know, right? They could go to the law enforcement instead of somebody finding out by a woman actually having an abortion. They could go to law enforcement, or if it's a public or private citizen who's allowed to sue, and say, hey, got some insight here on this company policy and procedure. Think they're breaking the law here. You've got some issues there. Nobody's really thinking about how we're going to handle whistleblowers. So those are the main, just kind of off the top of what we're seeing, the main privacy concerns, security concerns that we are getting. There's so many more out there, and we will cover some more in a later session. There's a lot of information too, kind of about how this has international privacy implications for companies that do work kind of both in the US, but also have partners in the EU or other countries. So we'll cover that at a later session as well. There was a question on whether you can share any of this information on LinkedIn. Yes, please share this information. The goal is to get it out there. It's to make sure that everybody's able to navigate this space in a very safe manner, and it's very much changing, right? So we are going to be keeping you all up to date on this. We're going to be hosting these webinars over a long period of time, especially as things change. So please push this information out there. There will be a recording of this available. If you've signed up, you should be getting the link for the recording when it becomes available. And so please feel free to share that as well. So thank you. I know that we're 1 minute over. I really appreciate everyone attending today and hearing this. Again, if there's topics that you want to see on these webinars, questions specifically that you have that you want to see covered, please reach out to me, LinkedIn or email, and I can get those on the schedule and make sure that we're providing relevant content to you. So thank you so much. I'm here if anything else pops up, any questions you have, and thank you all for the wonderful work that you are doing in this space.